By this video 106, we shall be discussing one more type of borrowers, which is the companies, and the topic contained in this video is based on JAAB Paper 2 Principles and Practices of Banking, Module B Functions of Banks, Unit 22. In this channel, various credit lending topics based on JAAB and CAAB latest syllabus will be discussed in simple language through small videos. It is certain that those who read and understand the topics covered in the videos will find it very easy to appear and pass in the JAIIB, CAIIB and DBF examinations. Companies. A company is a juristic person created by law. Indian Companies Act 1956 modified in 2013, having a perpetual succession and is distinct from its members. It has rights, liabilities, powers and duties prescribed by law. It can do all acts as a natural person may do. Characteristics of a company. A company is a voluntary association of persons coming together to carry on business for profit. It has perpetual existence. Change in its members does not affect its existence or identity. Only law can dissolve it. The shares of joint stock companies are freely transferable. For a private limited company, legal restrictions apply on transferability of shares. A member can dispose shares as per his choice, subject to any regulations of the company. The shareholder's liability is limited to the nominal value of the shares held. A shareholder is not required to pay more than the unpaid value of his shares. For a company limited by guarantee, the members are liable only to the extent of the amount guaranteed when the company goes into liquidation. A company is entitled to own and hold property in its own name. A company can sue and be sued in its own name. As per the Companies Act 2013, company is registered as public company or as private company. Private company by its articles of association restricts the right to transfer shares, limits the number of its members to 200 except one-person company, which is shortly known as OPC, prohibits invitation to the public to subscribe for any securities of the company. Types as per liability: companies limited by shares, companies limited by guarantee with or without share capital, unlimited companies with or without share capital. Public company shares are freely transferable, no restriction on number of members. Public at large can participate in its share capital. Government company, central government or state government or partly both of these have not less than 51% of the share capital. One-person company, one person as member, paid up capital up to rupees 50 lakhs. The average annual turnover of in the preceding 3 years should not exceed rupees 2 crores. Small company, again paid up capital up to 50 lakhs. Turnover last year should not exceed 2 crores. Other types of companies: foreign company, any company or body corporate incorporated outside India which has a place of business in India by itself or through an agent. physically or through electronic mode and conducts any business activity in India in any other manner. The next one is a holding company. A company in relation to one or more other companies of which such companies are subsidiary companies. 3. Subsidiary company. A company in which the holding company controls the composition of the board of directors, exercises or controls more than one half of the total voting power, either of its own or together with one or more of its subsidiary companies. Basic laws governing companies. In India, the companies are registered and governed by the Companies Act 2013. Number of members. CA 2013 provides that a company may be formed for any lawful purpose by 7 or more persons for public company, by 2 or more persons for a private company, and by 1 person for 1 person company. Further, an association or partnership firm carrying on business for gain cannot have more than the prescribed number of persons, maximum 100. The Companies Miscellaneous Rules 2014 has prescribed the maximum number of persons in an association or partnership to be 50. On exceeding this, if not registered as a company, it will be illegal. Incorporation of company. CA 2013 provides on the basis of documents and information, including the memorandum and articles of the company, duly signed by all the subscribers to the memorandum, filed with the registrar, within whose jurisdiction the registered office of a company is proposed to be situated. It shall register all documents and information in the register and issue a certificate of incorporation. Requirements of forming a company. The promoters have to decide name of the company, type of the company, memorandum of association, shortly known as MOA, and articles of association, AOA, the business and objects of a company and the rules and regulations governing its management are known by two important documents called Memorandum of Association and Article of Association. What is Memorandum of Association? The MOA is the charter of the company and enables the shareholders, creditors, and those dealing with the company to know its permitted range of business. It contains the following details among others: name of the company, state where the registered office is situated, objects, liability of the members, share capital and its division. It defines the area within which the company can act. Hence, it should have the object for which the company has been formed and various business it can undertake, etc. MOA must be examined to check the business undertaken by the company is within its objects. If not, any loan to the company would not be recoverable. What is Articles of Association? AOA are rules and regulations governing the internal management of the company. They define powers of the officers of the company. AOA is subordinate to MOA and contains the following details: number of directors of the company, procedure for conducting meetings of the shareholders, board of directors, procedure for transfer and transmission of shares, borrowing powers of the company, officers of the company, and other details. Certificate of incorporation. On the registration of the MOA, the registrar shall certify under his hand that the company is incorporated. A certificate of incorporation, COI, is issued to this effect. The company come into being from the date of incorporation mentioned in the COI. Name of company. The MOA of a company should state the name of the company. The promoters are required to submit at least 3 suitable names in the order of preference. The name of the company must end with the word limited for a public company and the words private limited for a private company. For a Section 8 company, the word limited can be dispensed with by obtaining a license from the regional director. The Company Act defines a Section 8 company as one whose objectives is to promote field of arts, commerce, science, research, education, sports, charity, social welfare, religion, environment protection or other similar objectives. The Companies Act prohibits any name for which is undesirable, which is identical with or too nearly resembles the name of an existing company. Also, a company cannot use a name prohibited under the Emblems and Names Prevention of Improper Use Act 1950. Also, the name should not be misleading or intended to deceive with reference to object clause. Commencement of business. In July 2019, CA 2013 providing that a company having share capital shall not commence any business or exercise any borrowing power unless a declaration is filed within 180 days of the date of incorporation by a director with the registrar that every subscriber to MOA has paid the value of the shares agreed to be taken by him, and the company has filed with the registrar a verification of its registered office. Common seal, optional. CA 2013 required common seal to be affixed on certain documents such as bill of exchange, share certificate, etc. that has been made optional. Instead, these may be assigned by two directors or one director and the company secretary of the company. Incorporation of company limited by guarantee. The procedure for incorporation of a company limited by guarantee is similar with certain distinctions. MOA of such company, a clause stating that the amount of guarantee is added. A guarantee company may be a company with or without share capital. A company formed with no intention to generate profit is usually formed as a guarantee company. A company limited by guarantee can either be a private or a public company. Subscribe to my channel, which is totally free of cost. Subscription will be giving you an intimation on the new modules being published. More videos based on JIB and CIB syllabus based credit lending topics are to be published. Thank you very much, and the YouTube channel is NPIers Learning Modules on Lending.